we're doing here today. Over the past 2 years, we've really seen the Trump administration make treaty withdrawal something of a signature move. From the Treaty of Amity with Iran to the Intermediate Range Nuclear Forces Treaty to the optional protocol for the VCDR, the administration has taken steps to remove the United States, rightly or wrongly, from a wide array of long-standing international legal obligations. And while it's far from unprecedented, the administration has done so at a little bit of a faster pace than certainly prior administrations have, and has embedded a lot of these moves in a consistent critique of international institutions and international commitments that promises further change on the horizon. A heated point of debate on that further change has been the North Atlantic Treaty and the NATO alliance that it undergirds. That treaty, despite widespread bipartisan support for that treaty, President Trump has been notably critical of it. There have even been media reports that he's raised the prospect of US withdrawal in internal meetings and potentially even with NATO allies. This has led a lot of people to ask one question: what can Congress do about it? And the answer to that is really quite unclear. The president's control over treaties and treaty withdrawal has been a matter of practice. It's something that he's exercised, mostly uncontroversially, with a couple of exceptions for most of the last century, unilaterally. But in efforts to challenge it that have been put forward by members of Congress or private citizens have failed to reach the merits to date, instead falling short on ripeness disputes and standing disputes and political question doctrine disputes. But none of these challenges have addressed a situation where the president is seeking to withdraw from a treaty at a spot where his power is truly at its lowest ebb, a circumstance where the Congress has enacted a law, a binding prohibition on the action the president is trying to take or treaty withdrawal. And that's the scenario we're debating here today. The focus of our debate is SJ Res 4, a joint resolution introduced in January, in the real world, I should say, by a bipartisan coalition of senators led by Senator Tim Kaine. This resolution enacts another number of measures in relation to the North Atlantic Treaty. But for the purposes of this debate, the most important are the first two. Section 1 installs an explicit prohibition on the suspension, termination, or withdrawal from the North Atlantic Treaty absent advice and consent of Senate, or the permission of an act, or pursuant to an act of Congress, excuse me. And Section 2 similarly limits the authorization or use of funds for this purpose. In this way, this act is intended to establish a clear prohibition on the president's unilateral withdrawal from the North Atlantic Treaty. For the purpose of our scenario, we are going to assume that SJ Res 4 is enacted into law later this year as part of the National Defense Authorization Act for fiscal year 2020, a compromise bill that the president does not veto, in part because it includes some funding for the US-Mexico wall project that he supports. In November 2019, however, the concept of NATO and US involvement in NATO again becomes a politically charged issue, in part because of President Trump's opposition to the accession of North Macedonia to NATO. On December 26th, President Trump, by tweet, announces that he intends to withdraw the United States from the North Atlantic Treaty. And the next day, the State Department issues the formal notice of denunciation pursuant to Article 13 of that treaty, indicating that withdrawal will take an effect in 1 year. Pursuant to Section 4 of SJ Res 4, the Senate enacts a resolution with a slim bipartisan majority to authorize legal counsel to represent its interests in opposing the president's actions as unconstitutional. The House endorses this action subsequently. Counsel for the Senate files a suit in the district court, federal district court in the U.S. District of Columbia, and early phases of the litigation resolve questions of ripeness, political question doctrine, and standing in favor of the plaintiffs, in favor of Congress, or the Senate, I should say. The district court then moves on to the merits and rules in favor of the president, finding that treaty withdrawal is an exclusive authority of the president. That decision is now on appeal before the Court of Appeals for the District of Columbia Circuit, and that is the argument we will be hearing today. So with that, oyez, oyez, oyez. The United States Court of Appeals for the District of Columbia Circuit is now in session. All persons having business before the Honorable Court are admonished to draw near and give their attention. Case number 19555, United States Senate Appellant v. President Donald J. Trump. Mr. Fanzone for the appellant, Ms. Anders for the appellee. Mr. Fanzone.
Your Honors, may it please the Court, Chris Fanzone representing the Congress in this case. Under the Constitution, treaties are the supreme law of the land, and the President can only enter into them with the advice and consent of the Senate. Here, Congress, as part of its role in enacting legislation to determine the law of the land and consistent with a long history of legislating on the domestic effect of treaties, passed a statute to prohibit the President from terminating the United States' participation in the most important mutual defense treaty in our nation's history, a pillar of world order and stability. The district court erred in concluding that the Congress did not have this power and that the power of treaty termination is exclusively the President's, and its decision should be reversed. Congress has ample authority to pass this legislation. In addition to the explicit treaty-making power bestowed upon the Senate, the Constitution grants Congress the powers to, among other things, regulate commerce with foreign nations, declare war, and make rules for the government and regulation of the armed forces. Congress also has the power of the purse, which is explicitly employed here by denying the President the use of funds to withdraw from NATO. And importantly, the Constitution grants Congress the power to make all laws which shall be necessary and proper for executing all the other powers the Constitution has bestowed upon it. These powers plainly enable the Congress to enact legislation that prohibits the President from withdrawing from NATO. Indeed, there is a long history of Congress legislating in the wake of a treaty to give it domestic effect. It is unquestioned that Congress can trump a treaty through subsequent legislation. This law, S.J. Res. 4, therefore binds the President. As stated in Zivotofsky, the President is not free from the ordinary controls and checks of Congress merely because foreign affairs are at issue. Indeed, the Supreme Court has never even endorsed the President's authority to unilaterally terminate the United States' participation in a treaty, even in the absence of legislation prohibiting him from doing so. Here, however, the President claims an even greater power, the power to terminate a treaty over duly enacted legislation prohibiting him from leaving the treaty. As Justice Jackson put it in his Youngstown concurrence, claims of exclusive presidential power like this face a severe test and must be scrutinized with caution, since sanctioning such a claim would disable the Congress from acting upon the subject and thereby threaten the equilibrium established by our constitutional system. As noted above, there is simply no precedent that requires this court to take this step, and text, history, and prudence all counsel against doing so. In terms of text, there is nothing in the text that grants the President exclusive authority over treaty termination. To be sure, the Constitution vests the executive power in the President and makes him the commander-in-chief, grants of authority that have been understood to provide certain implied authority with respect to the conduct of diplomacy. But treaties are not simply diplomatic measures, they have the force of law. Moreover, the treaty clause establishes that treaties are subject to the shared authority of the executive and legislative branches, dividing the power to make treaties between the President and Congress, and remaining silent on the power to unmake them. Second, history. The Supreme Court has suggested that in separation of power cases, historical gloss can serve as a source of constitutional authority. There is no such gloss here. Of course, the President has, in recent times, withdrawn the U.S. from treaties unilaterally, but this practice is not on force here. One, it's not unquestioned. Substantial contingents of legislatures have opposed these actions by the President. Second, the practice is far from unbroken. Right after the founding in 1798, it was Congress that enacted legislation withdrawing the United States from a treaty, which is consistent with the understanding that the founding fathers believed only Congress could terminate treaties. And consistent with this, Congress, or at least the Senate, played a substantial role in treaty termination throughout the 20th century. Third, and most importantly, the President's recent unilateral withdrawals are not the same as this one here. Those were done typically consistent with treaty termination provisions of the treaty themselves and not over explicit statute prohibiting it. Finally, functional considerations are often relevant to separation of powers cases. But upholding this law does not implicate the President's need to act with secrecy and dispatch or his ability to recognize which foreign governments are legitimate in the eyes of the United States. Rather, this is a narrow case limited to the act of withdrawing from the North Atlantic Treaty, which requires 1 year's advance notice in any event, hardly something the President can do with dispatch. In this case, does not, and even if this law was upheld, the President would still have the authority to suspend or terminate a treaty for material breach pursuant to international law, or because in his judgment his take care responsibilities require it. In short, there is simply no reason for this court to destabilize the careful balance established by the Constitution by allowing the President to ignore duly enacted legislation simply because it touches on foreign affairs. I'll now take your questions.
Okay. Counsel, My question really relates to the breadth of your argument. I'm trying to figure out how broadly you're asking this court to rule. What if a treaty addressed an issue relating to recognition of a foreign sovereign or its territory, or if a president concluded that continuation of a treaty would be inconsistent with his or her policies about recognition? In fact, I think President Carter's view on the Taiwan treaty was that continuation of it would in fact be inconsistent with his recognition of mainland China. Are you arguing that Congress has plenary authority to restrict his options even in the recognition realm that was covered by Zivotofsky?
I don't think I need to take that position in this case. I think in this case, the treaty here would, the substantive provisions of the treaty would be within Congress's authority. In the cases you're talking about, if the substantive provisions of the treaties bind the president in ways that would be inconsistent with Congress's authority, I think that would be a different case. It wouldn't necessarily, you wouldn't necessarily have to reach that question by ruling in Congress's favor here.
So does that mean then that the fact that the textual hook that you rely on, which is the Senate's advice and consent power with respect to treaties, really doesn't play very much role in the analysis, because that would be equally true in the recognition case?
Yeah, I think that I think there's several authorities that rely on here. There's the ability to regulate foreign commerce, the declare war clause. I think that alone, you do not need to rely on that alone in this case to rule in Congress's favor. I think that I don't know how we would consider a different case whereby that would be the only hook for this argument. And I think, although I do think if you would, if you would rule that Congress is disabled from doing this, that you would also be ruling, for instance, that Congress cannot put in place, the Senate cannot put in place reservations and understandings that would prohibit withdrawal, that would seem to be a pretty aggressive position. I don't think the court has ever ruled that those sorts of things are unconstitutional in the way that you're discussing. So I don't think we need to reach that question. There's other powers that are relevant here, but I do think that would be an aggressive position.
But on your functional arguments, the President's Counsel in her brief makes the point that the nation needs to speak with one voice, and that voice should be the President's voice. My concern is that if we go down the path you're encouraging us to, that we'll end up in a Brexit-type situation. I mean, to make the point more focused on U.S. constitutional law, shouldn't we follow, shouldn't the one voice theory prevail here along the lines of Zivotofsky, that at least as far as we're talking about the international plane for treaty withdrawal purposes, Congress can do what it wants to on the domestic plane, can incorporate international norms domestically into statute. But when we're talking about the effect on the international plane with treaty withdrawal, that's really for the president to be the one voice.
Yeah, I think there's certainly a reason why the president is alone has the power to conduct diplomacy, but Congress and Zivotofsky itself recognize that the congressional role in foreign affairs must be understood and respected, and Congress in all sorts of ways establishes a baseline against which the president conducts diplomacy. There's nothing in this legislation that would preclude the president from saying, I think we should pull out of NATO. I think NATO is past its time, to encourage our NATO partners to spend more on their defense, to encourage Congress to pass legislation that would allow him to withdraw from NATO. I think you end up in situations a lot of times where Congress and the president are in different places with respect to foreign affairs issues, and I don't think there's anything about this law that would change that.
What if the president concluded in a particular instance that he or she needed to withdraw immediately from an existing treaty because the treaty was disabling him from or her from protecting the interests of the United States in a moment of crisis?
Yeah, so I think that's I don't think our argument reaches this. So I think our argument.
Well, why not? Why not? I mean,
so
if you could pass this statute, you could pass another one that would cover a different treaty, I assume.
Right. So I think that I almost view this as a distinction between this statute being facially constitutional, but to the extent that there's a set of circumstances that arise, in which case the president would feel the need to, because of a foreign policy crisis or a national security crisis, take action inconsistent with the treaty. He could either suspend the treaty because one of our counterparties are in material breach of it. He could, sort of on an as-applied fashion, argue that the treaty is unconstitutional because it's constraining his exclusive authority. I think here, on its face, the treaty is not infringing on any of the president's exclusive authorities, and therefore I think that it's a valid use of Congress's authorities.
Counsel, given that the president has already initiated on behalf of the United States the withdrawal notice period, Are you asking this court, the federal courts, to order the president to engage in a new diplomatic act of revocation of notice? And if so, do you have any judicial precedent in which courts have ordered the executive to engage in a particular act of diplomacy?
I don't think we're ordering the president to engage in a particular act of diplomacy. We are just defining what the effects of the diplomatic acts he's taking are. So the president can, I think we're saying that the president's actions to start withdrawing from this treaty are not, he does not have the power under our domestic law.
But under international law, his actions are entirely effective as far as I understand international law. The head of state's notice of withdrawal will be given full effect unless it's withdrawn.
So I think, I do not think, I think that the president, under U.S. domestic law, the president does not have the authority. This would withdraw any authority the president has to terminate this treaty. Therefore, as a matter of domestic law, he would not be able to do it. Whether or not on the international plane his action would be considered valid, I think, is a separate question from whether the statute is constitutional as a matter of
You might be
law.
content with the declaratory judgment, it sounds
Yes, I think that's what I'm saying.
So just to follow along Justice Bradley's line of questioning, is your argument essentially that the announcement of the treaty withdrawal, the notice that the president gave internationally, has no legal effect? So in other words, it wouldn't require revocation if it had no legal effect to begin with. Is that what you're asking us to order?
Yeah, that's correct. Judge Bradley, I think you got a promotion there.
Oh, I'm
but
sorry.
that's okay.
Sitting by designation.
I think that, yes, as a matter of domestic law, it wouldn't have effect. I think there's a different question of international law, so it would be a declaratory judgment we're looking for. We didn't really brief the remedy before the case, so that's a...
So how do you
Council and panel, we have 3 minutes, just for your awareness.
How do you square your position with the fact that the text of the Constitution gives only the Senate a role with respect to treaties?
So I think that...
You're asserting authority on behalf of the Congress
Yeah, so
in its entirety.
you're right. The treaty clause only gives authority to the Senate with respect to providing advice and consent to treaties. I think, the other authorities we're talking about here are given to the bestowed upon
But
the
this is a
legislature.
form of advice and consent, isn't it? It's like we're withdrawing consent. That's
Right, but I mean, I think historically, congressional executive agreements, the validity of them and how they're sort of interchangeable with Senate advice and consent show that these things are sort of interchangeable. The full Congress also has the possibility of enacting legislation to govern the domestic effect of treaties, including the authority to enact legislation that accomplishes the same things as reservation and understandings would. So I think in that case, there is some fungibility between things that the Senate can do through advice and consent and stuff Congress can do using its other powers, through other constitutionally bestowed powers.
All right. Got 2 minutes remaining. You're welcome
I'll
to reserve for
reserve
rebuttal.
the balance of my time.
Yeah. Counsel for the appellee, Ms. Sanders.
Thank you. May it please the court, Ginger Anders for the United States. The president possesses the narrow but exclusive constitutional authority to withdraw from a treaty as a necessary incident of his constitutional powers to make treaties and to conduct diplomacy. That conclusion follows from the Constitution's text, functional considerations, and historical practice, the same very three considerations that the Supreme Court relied on in Zivotofsky, where it held that the recognition power is exclusive to the president. Because SJ Res 4 purports to prohibit the president from withdrawing from Nato unless Congress agrees, it is an unconstitutional invasion of the president's exclusive authority. The district court's decision should be affirmed. Starting with the constitutional text, I think the president's exclusive power follows from two well-established principles. First, the president possesses exclusive authority to conduct diplomacy on behalf of the nation. Article 2 vests all executive power in the president. Since the time of the founding, the vesting clause has been understood to broadly grant the president the power to conduct foreign relations and to serve as the nation's sole mouthpiece in diplomacy. The act of withdrawing from a treaty is fundamentally a diplomatic one. The president must communicate to other treaty parties the official diplomatic notice that is required by the treaty itself. Second, the president possesses exclusive constitutional authority to negotiate treaties and to make the ultimate decision whether to enter into them, subject to a limited role in the Senate. So although Article 2 simply says that the president shall have the power to make treaties with the advice and consent of the Senate, it's understood that there are a number of implied powers that are exclusive to the president. First, the president has exclusive authority to negotiate treaties. The Congress or the Senate cannot direct him to negotiate, and they can't tell him what to negotiate. Second, the president has sole discretion to decide whether to sign the treaty and whether to submit it to the Senate for its consent. At that point, the Senate plays its only role, which is to consent to the treaty. But after that, even once the Senate has consented, the president is not committed to enter into the treaty. He has the sole authority to decide whether to ratify the treaty at that point. So even after the Senate has said, we have determined that the United States should enter into the treaty, the president can decline to do so. And I think that's really critical context here. The decision whether to enter into a treaty is just as weighty as the decision whether to withdraw from it. And that entry decision is committed to the president. President Truman could have declined to enter NATO, despite all the weighty reasons to enter into the alliance, and even despite a statute that told him that he had to enter into it. So I think those authorities together raise a strong textual inference that the president has exclusive authority here. By contrast, when you look at what the Senate or Congress can do, the Constitution does not grant them any enumerated power that could be used to withdraw from treaties. So first, with respect to the Senate, obviously the Senate does have a role in making treaties, but that limited and specific grant of authority can't be extended to something that's not textually committed. As the Supreme Court said in INS versus Chadha, the Senate may act unilaterally only where the Constitution has authorized it in explicit and unambiguous terms. As for Congress, the framers consciously decided not to give Congress a role in treaty making because they decided that the body was not suited to that kind of role in foreign relations. And more broadly, as the court emphasized in Zivotofsky, although Congress does have enumerated powers that touch on foreign relations, it doesn't have an enumerated power that is directed specifically to what we're talking about here, to treaty withdrawal. At the same time, though, I would emphasize that Congress has a lot of authority with respect to policy determinations surrounding whether to withdraw from a treaty. While the president has exclusive authority to withdraw as a matter of international law, Congress itself retains broad authority to reinstate a treaty's provisions as a matter of substantive domestic law, to prohibit or refuse to fund actions that the president seeks to take after withdrawing from a treaty. It has a number of practical things it can do to check the president's authority. And for that reason, presidents are usually well advised to consult with Congress before withdrawing from a treaty. Turning to functional considerations that the Supreme Court found dispositive in Zivotofsky, they also support an exclusive power. It's critical that the nations speak with one voice. If treaty termination becomes a matter for public debate before Congress, the nation's foreign policy could be muddied, and other nations could be unsure of our commitments, even if we end up deciding to stay in a treaty. Second, only the executive can act with speed and decisiveness. Often it can be necessary to withdraw from a treaty because of a crisis. One can imagine a bilateral treaty in which the president decides to withdraw because the other party has taken hostile action, or situations in which the president wants to quickly withdraw from a treaty in order to effectuate recognition of a new state, as was the case with the Taiwan Treaty. And sometimes continuing to comply with a treaty could become dangerous to national security. There could be situations in which the United States is foregoing certain military activities, and it becomes clear to the president that is no longer consistent with national security. So sometimes there simply won't be time for debate in Congress or the Senate. Only the executive can act in secrecy. The sorts of considerations I just mentioned can be the subject of classified intelligence, things that shouldn't be put to public debate in Congress. And finally, only the executive has the necessary expertise to decide whether to terminate a treaty. Because only the executive, as the court emphasized in Zivotofsky, has diplomatic agents and other sources of intelligence around the world that inform the executive, what the situation is internationally. And at the same time, the foreign relations considerations that go into deciding whether to withdraw from a treaty are often going to be the same sorts of considerations that the president took into account in deciding whether to enter into the treaty in the first place. And that decision is committed to him. And finally, I think—
Counsel, can I just jump in on your functional arguments before you move on? So I hear of a disagreement between, on the one hand, you're arguing that treaty withdrawal is a fundamentally diplomatic function. Opposing counsel argues that they also play a lawmaking function and tells us that, as you concede, that Congress can, of course, pass a later in time statute to override a treaty. Isn't that recognition that Congress has a lawmaking role in terminating treaties? I mean, it'd be another matter if this had just been an executive agreement, where not involving Senate's advice and consent from the start. But isn't there a lawmaking role in treaty withdrawal as well as a diplomatic function?
I guess I would separate out two things here. The first is the treaty as a subject of international law and the diplomatic exchange that goes into forming the treaty and then withdrawing from it. That is exclusively committed to the president. Now, it's also true under the Supremacy Clause that the treaty is the supreme law of the land if it's self-executing or if Congress has enacted implementing legislation. I think obviously the president's withdrawal from a treaty itself can in effect change the law if the treaty is self-executing, not if it's not self-executing. But I think that is not as strange as it first sounds because it is the president, of course, who has the ultimate decision whether to make that law in the first place. The Constitution commits to the president's decision to enter into the treaty and also to determine its substantive content by negotiating it. So I think in that sense, it is not odd the fact that there is a lawmaking effect, or there can be a lawmaking effect of the withdrawal decision. At the same time, though, I do think it is a significant check that Congress has on the president, that Congress can essentially pass a statute that tries to take away a lot of the effect of treaty withdrawal. And I think that is something that the president is well advised to consider and something that keeps the area of exclusive authority very narrow.
Can I ask you a question about the history? It is the case that in more recent times, maybe the last 100 years, that presidents have exercised treaty termination authority unilaterally with only intermittent pushback, if any, by Congress. But as I look at the 19th century history, it's quite different in that there was significantly more of a sense that this was a shared power between Congress and the president. So given that history is much closer to the founding, why shouldn't we give that history more weight?
So two main points with respect to that. The first is that, as the court emphasized both in Zivotofsky and in Noel Canning, the recess appointments case, a historical practice doesn't have to extend all the way back to the founding consistently for it to be something that is given a great deal of weight in terms of how the branches understand a particular constitutional provision. So the court has said that even a practice that begins in the 20th century can be relevant. So I think for that reason, it makes sense to look at the president's termination of dozens of treaties throughout the 20th century mostly without congressional pushback as evidence of the branch's agreement that the president had the authority to do that. And then particularly when you get to the Taiwan Treaty and the Anti-Ballistic Missile Treaty in 2002, there you have some objections being raised in Congress, but ultimately the Congress permitting the president to go forward, which that sort of interchange between the branches is the kind of thing that in Zivotofsky, the court said, this reflects Congress's recognition that the president possesses the exclusive authority. With respect to the 19th century history, I take the point that what happened in the 19th century was mostly that the Congress would pass a statute that authorized the president to withdraw from a treaty. I guess I'd make a couple points about that. One is that although those statutes purported to authorize the president to do that, they left him discretion whether or not to do it. And there's no evidence in any of those situations that the president actually disagreed when he went ahead and withdrew the United States from the treaty. I think we can look at that as a situation in which the branches consulted and they reached agreement. And then the other point I would make is that if you follow the approach that Zivotofsky took to the history, Zivotofsky looked at similar incidents where you had Congress and the president working together with respect to recognition. And what the court took out of that was, well, in each of those instances, Congress expressed an opinion, but it left the actual formal act of recognition to the president himself. And so that shows that that formal act was something that was thought of as exclusive to the president. And I think that's the same here, that all these statutes left it to the president to actually undertake the diplomatic act of withdrawing from the treaty.
Well, counsel, let me direct your attention to a more recent, more modern example. So in the 1980s, Congress enacted the Comprehensive Anti-Apartheid Act because of disapproval of South Africa's apartheid regime over President Reagan's veto, I think, directing him to terminate two treaties, I think an air services treaty and a tax treaty with South Africa. And he complied with that directive in the statute. Even though my understanding is his administration was generally quite robust in defending presidential power and making claims about exclusive presidential authority. When I look at that even recent history of congressional involvement, that doesn't seem to fit the usual pattern of exclusive executive conduct. What are your thoughts about that?
Well, I think that in all of these cases, the history has never been all on one side or the other side. And so I think what the court has done in Zivotofsky and again in Noel Canning is look to the sort of broad sweep of history and what it shows overall. And so I think there were also instances, there were similar instances in Zivotofsky where it appeared that the president didn't want to recognize and a particular state, Congress wanted him to, and eventually the president complied. And I think those instances the court understood as situations in which the president, for political expediency, went along with that. And I think that points up an important point, which is that presidents are not going to exercise this unilateral withdrawal authority lightly. This is a situation in which it makes sense to consult with Congress and to see what Congress thinks. And Congress has a lot of ways to make its views known and to essentially penalize the president for taking action that Congress doesn't agree with.
So this isn't really before us, but are you willing to concede that there are some circumstances, say with a congressional executive agreement, like a trade agreement, let's just say hypothetically NAFTA, that the president would not be able to withdraw from without the consent of Congress?
2.5 minutes, counsel.
I think the congressional executive agreements may present a more difficult case, but again, I think you can separate out the diplomatic act of withdrawing from the treaty or the agreement, and then the domestic effects of that. Now, congressional executive agreements are implemented by legislation. Obviously, the president can't repeal that legislation without the participation of Congress. So while the president may be able to communicate the diplomatically the act of withdrawing, that may not mean very much in practice. And so I think that's another situation. That's another way in which the president's authority as a practical matter is cabined here.
If I could just ask, hypothetically, if we hypothetically had a demagogic president who just completely went rogue and decided to renounce virtually every treaty commitment we have that, for decades and decades have been the foundation of our national defense, is it really your position that Congress is just powerless to prevent a rogue president from doing that? That seems just so inconsistent with the whole notion of separation of powers under our Constitution.
Well, again, I had 2 points on that. I think the first is that as a practical matter, Congress does have significant ability to check the president. And that is, if Congress desires, that is something that Congress can exercise, for instance, by legislating to tamp down the domestic effect, denying the president, confirmation of ambassadors. There are things that Congress can do. And the second point I would make is I take the court's concern very seriously, but I guess I would urge the court to keep in mind the limited role of the judiciary in foreign relations, that of all the branches, the judiciary has the least role in foreign relations. And so while there may be situations in which there are policy disagreements with the president, one can think of reasons why it would be bad policy to withdraw from a treaty. The court should not succumb to the temptation to limit executive power as a whole, just because of disagreement with a particular president. Rather, the court should decide the case based on neutral legal principles.
Is there time for one more question, or do you want to go ahead?
Time is up,
Go ahead.
sadly.
Yep.
Mr. Fonzone, you have 2 minutes.
Thank you. In closing, in rebuttal, is 2 points I'd like to make. 3 points I'd like to make, actually. One is just to address Judge Bradley's question about ordering the president to take a diplomatic act. I think that's not the case here. And as I've thought about it, basically, as we work through, it's denying the president's act domestic effect. As a hypothetical, let's say the president had made a treaty and then ratified it without receiving Senate advice and consent. I think a court could issue a declaratory judgment saying that the treaty does not have domestic effect, is not the supreme law of the land, which I think would be similar.
But under international law, a manifest violation of the Constitution, like the advice and consent clause, might actually remove the U.S. consent to the treaty. But I know of no such international law rule for notice of termination. So I think the U.S. will have withdrawn from NATO if all we issue is a declaratory judgment.
So it's still, and this gets back to, I think, some of the distinction that Councilor Anders was making between international and domestic law. I think the issue here is the treaties are a matter of domestic law, and I think that the Senate, the Congress can pass a statute precluding the president from as a matter of domestic law from withdrawing from the treaty as a matter of U.S. law. In closing, just one final point I'd like to make is that as Justice Jackson recognized in Youngstown, there's only been the president's power is at its lowest ebb when acting contrary to the will of Congress. Here he's clearly acting contrary to the will of Congress. There's only been one case in the history of this country where the Supreme Court has ruled that such action is the president has the constitutional authority to proceed in those circumstances. That's Zivotofsky. I think the textual hook and the history is far different there than it is here. And for those reasons, I think that the statute should stand.
Thank you.
Thank you.
Applause for our counsel, I think. So I'm vacating a seat, but really I'm handing the floor over to our three judges. In lieu of a written opinion, we don't have to wait 3 or 4 months or more than that to hear their opinions. We get to go directly to the source. Judge Bradley, I'll start with you. What is your take on this sort of set of issues as we have them?
I think we ended up being, by happenstance, a little bit tougher on the appellant, on Chris. Doesn't necessarily mean that was the tougher position to argue, it strikes me. I think for most judges, the phenomenon that Zivotofsky represents of the president being able to disregard a duly enacted statute should be a very rare event, and so he should be operating from a position of strength, particularly given that the very thing that the president's withdrawing from required 2 branches to create, which is very different from some of the unilateral executive things like receiving ambassadors, which do not require Congress. So we already are operating from by 2 branches of government, and then all of a sudden we move to 1, and maybe we're willing to acknowledge that the president over time has developed a unilateral independent power to withdraw from those things that took 2 branches to create. It is a big step to then say the Congress can do nothing with respect to those unilateral acts, given that Congress periodically, not a lot in the 20th century, but some, have mucked around with treaty termination without a constitutional crisis, with the president usually going along in some capacity. It's not like regulating how the commander-in-chief does battle or something, where the presidents would go to the mattresses on fighting against any congressional interference. So in that sense, I thought the argument might actually be a little easier in the real world for the appellant. Historical practice is such a big issue, and that many judges will only want to talk about text or something like that, and other judges will be comfortable with practice, like in Zivotofsky or Noel Canning. I think history should be hard for the prevailing party here, the president, given that we have no practice of the president ever terminating a treaty in the face of a contrary statute. And I might have pressed a little bit on that. Show me the practice of that. And if the only practice, now having said that, Zivotofsky is pretty loose on this. And so I have to acknowledge that Ginger is right about that Zivotofsky often took just evidence of the president acting alone as somehow evidence of the practice of the president being completely unregulable. And that is the Supreme Court decision. But I personally would have probably pushed back on that.
Really, please.
So, I'm going to suggest actually that Judge Powell speak next because, flanking me are 2 unbelievable experts on the issue we're discussing, and I just happen to be the guy who argued Zivotofsky. So I do have some thoughts about it, but I think it would make sense, Catherine, if you don't mind to go next, and then I'll follow up.
That works for you, Judge Powell.
Thank you. So I actually felt really torn on this issue. And as we were preparing for this, I was reminded of a conference I spoke at last spring that the Federalist Society organized at NYU Law School, which was called something like Beyond Trump. And it was really about how do we think about both courts and Congress restraining the president and precedent that can be made in this moment, and how that precedent will, of course, constrain future presidents. And having worked for the executive branch, as I think all of us have, it's sort of like where you stand depends on where you sit, or, that expression that on the one hand, I do feel sympathetic to giving the president some flexibility. And so I'm mindful of the precedent that we set here today for future presidents. But at the same time, I think if we look at the Supreme Court's decision-making following 9/11 and the detention context, and the fact that, the court said, war is not a blank check for the president, even though it in effect had been seemingly in some prior decisions, say Korematsu, which of course the court has recently overruled. But I get the sense that the court is mindful of the fact that there do needs to be some checks and balances on the presidency, given the broader context of post 9/11 and some of the excesses that we became aware of through leaked memos. Here too, I get the sense that we've seen judges have been mindful of the need for checks and balances on the presidency. And so In the end, I really am torn, but I'm mindful of the fact that courts are aware of the broader context post 9/11 and now in this moment.
Great.
Really?
So thinking about this sort of through the lens of Zivotofsky is interesting. We didn't talk at all in the arguments or in the questioning about the threshold issues of whether this could get to court, but there's a serious doubt whether this issue could get to court. I think in the manner that this statute created, there'll be a serious fight. It may be that this is a situation where you can find legislative standing to allow this to be adjudicated. But boy, that would be a gigantic fight, and not one that I think the current court, not one you'd bet on winning in front of the current Supreme Court. And therefore, there's a way in which, because of that, the political checks that Ginger argued in her argument as a substantive matter may actually be, as a practical matter, the way in which an issue of this kind gets worked out. But putting that aside and talking about the more interesting piece of it, which is, as a substantive constitutional matter, what's the right answer? My sense of this is that, had you asked me before the court ruled in Zivotofsky, and when Ginger and I were writing the briefs and preparing for oral argument, if you'd asked me this question then, I would have said, oh, there's no way the executive could win that case, because we thought it was going to be an uphill fight to win Zivotofsky, or at least to win it in a broad fashion. In fact, as we were working it through and getting ready for oral argument, one thing that we decided to do was to really scale back the scope of what we were claiming was exclusive executive authority. And what we scaled it back to was the notion that Congress can't regulate diplomatic communication by the president, and that the content of passports needed to be understood as diplomatic communication because they're in the form of a letter from the Secretary of State. And we really went into oral argument thinking we wanted to sustain our position and validate the statute on that narrow ground, because we really didn't think we had a great chance of winning on the broader ground. And then lo and behold, we won on the broader ground. And I think in Zivotofsky, at least, the functional considerations played a pretty big role in that. The notion that if you started to think about how would Congress actually, how would giving Congress this power actually work out in practice, the idea of as Catherine did, I think, in her first question, the notion that, that Congress can contradict what the president says, and so the position of the United States, as far as the world's concerned, is completely indeterminate. That doesn't seem like it could be right. Those considerations seem to me like they've got some real force here too. Maybe make it a stronger case for the president than you might think going in. And then with respect to the history, probably, I guess the history here is not as uniformly helpful to the position of the government as it was in Zivotofsky. But Noel Canning, the other separation of powers case I did that really turned on history, the history wasn't entirely one-sided in that one either. It's just that the weight of it seemed to be in favor of the government's position. And then, here, even though it's true the history is a little more indeterminate, one other thing is true too, which is Congress has never actually passed a statute like this, right? And so the fact that we're this far into the country's history and Congress has never purported to assert this authority before is a consideration that I think would weigh against the assertion of the authority. So I actually think, my instincts are probably the same as the other judges, that the right answer here ultimately that you would predict would come out of this case would be that Congress could constitutionally enact a statute like this. And but I think it would be a closer case than you might think at first blush.
Absolutely. Thank you. Why don't I turn it over to the council a little bit just to give some reaction? You can step out of your advocate roles and give us a sense about your views and kind of the way you wade through these different arguments.
Yeah, okay. Yeah, so I think having been an executive branch lawyer for so long, I think it was, my instincts gravitated towards the president's position anyway, especially having done Zivotofsky. I do think this seems like a harder case than Zivotofsky, in part because the action that we're talking about seems more consequential. I mean, as Catherine said, it has a lawmaking, or it has an implication for what is the law of the land in a way that recognition does not. And so that to me seems like something that would give judges pause when they think about it. They're not used to thinking of the president as someone who can essentially change the law if it's a self-executing treaty. And I think, there are some answers to that, but ultimately it seems like a heavy lift. At the same time, for me, the functional considerations that Don mentioned do seem really persuasive. It's hard to imagine how this would play out if you actually did have to go to Congress and have some kind of debate on the House or Senate floor. That seems like something that could be tremendously harmful to foreign relations, to national security, and it seems like something that will push the court towards not wanting to tie the president's hands in that way, because the courts are pretty well aware of their relative lack of confidence in foreign relations, and so they are more willing to accept executive branch claims that that the executive needs some sort of authority to act fast, to act on the national stage, the international stage, and so I think that also that instinct may make this sort of a closer case.
Sorry.
I think it's
Yeah, it's around. Oh, yeah. So, I mean, I think as also someone who spent a large majority of his career in the executive branch, it's a little unusual arguing the place of Congress. But the thing that always struck me when these issues came up when I was in government was that they're sort of thrust upon the president. And I think this is why people think there's a steady accretion of power to the president over time, because these issues come up, the president could organize himself to argue him or herself to argue those issues and either go to court or just seize the power from Congress. And Congress, obviously, because it's a much more diffuse body, it's much harder for them to organize. So my view has always kind of been, in those rare instances where Congress can actually enact legislation, the bar for it being declared unconstitutional is like extraordinarily high. And Zivotofsky and as Don and Ginger both said, like, I think heading into it, I was very surprised where the court landed because of this reason. This case, I mean, I think, so given that background, I'm very sympathetic to Congress's position here, despite the fact that I'm sure if I was in government, I would be arguing the other position if I had to. I think the thing that makes it tricky, and the hardest argument, and the one that I stumbled with both preparing and when I was up there, is the question Kurt asked about, this seems to be forcing the president to take a particular diplomatic position. I'm not as worried about the sort of sole organ thesis, because there's all sorts of times, I experienced a lot when I was in government, where the president says one thing and Congress says another, or Congress invites a foreign leader to speak before it, or Congress sends a letter to a foreign leader taking a different position than the president. So I mean, there's all sorts of times when the U.S. isn't necessarily speaking with one voice, but it does seem like in this sense, Congress in some ways is like ordering the president to take a diplomatic act, but that's because treaty making it sort of lies in the fissure between diplomacy and lawmaking. And I think I think your presumption should be that Congress's actions are constitutional. I would sort of tilt it towards the lawmaking side of things rather than the diplomatic side of things, and think that Congress probably is the right side of it. But it's a tricky issue. I also agree with Don that it seems very unlikely that if this issue actually came up, the court wouldn't do absolutely everything it could to not have to reach it on the merits.
Well, let me broaden the aperture a bit. So we designed our hypothetical here to bypass a bunch of issues because we had limited time. We want to focus on the constitutional heart of it. But let me poke you all on a couple other side issues that we kind of ruled out. You'll notice the law here isn't just addressed towards treaty withdrawal, which is what we were debating here. Treaty withdrawal happening pursuant to the North Atlantic Treaty's terms itself. It also covers two other remedies or means of exit for treaties: termination and suspension. Suspension, both of which are remedies, can be pursued in response to material breach. That is one remedy we've seen the Trump administration invoke already in regards to the INF Treaty. They've suspended the INF Treaty in addition to pursuing withdrawal pursuant to its terms. Does the argument change? Does the constitutional distribution of authority change if you're talking about those other remedies that, I should note, aren't in the treaty itself? They actually come from customary international law, at least in regards to the United States, and particularly in regards to suspension, because an emphasis on the pragmatic prudential considerations is often the need for the president to respond quickly. Suspension is a mechanism that allows you to respond to material breach, which presumably is most often the situation where you would have to respond quickly by ending treaty obligations. Any thoughts on that from our panel?
I do think just didn't have time to ask it. I was going to ask whether the position was the same for suspension as for termination or withdrawal. I do think the functional arguments will appear to be stronger for the suspension scenarios, which might involve material breaches of the treaty, for example, in which the president will have better information, be able to exert direct leverage to try to improve compliance with the very thing the Senate agreed to before, which might be promoting the policy of the treaty, and seems more naturally to fall within the kind of day-to-day responsive actions of the diplomatic arm of the government. I'm a little bit less persuaded by the functional arguments when you're talking about a 1-year notice withdrawal period, which we're all waiting for a year to see what happens. It doesn't sound as exigent to me, but suspension is designed not to permanently alter the status quo or remove the supreme law of the land, but to put leverage on parties, often in response to their own conduct. And I think it's an easier argument for the president on that one.
Chris, yeah.
And I don't know if analytically this is a facial as applied distinction, but I do think that Congress passes a lot of laws that impact the president's ability to do things that he wants to diplomatically or with respect to national security. And rather than challenging them facially, which is sort of what the challenging the withdrawal is like here, I think there are times in which the exigent circumstances would require you to act inconsistent with that law in almost like an as-applied fashion. That's a much easier case. I think the perfect example, I think of, just probably because we all think about the things we did when we were in government, is the Bergdahl transfer. Like, even if you have the position that the Guantanamo transfer restrictions or Congress has that authority as a general matter, there could be a circumstance when the pressing needs of diplomacy require you, or national security require you to act contrary to them. And I feel like that would be a better case for the president in this sort of circumstance if Congress passed a general law and there's a reason why immediately we have to withdraw from NATO or not fulfill our NATO obligations. That would be a different case, I think, than this one.
And actually, we're going to turn to the audience for questions. If you want to start lining up, you're welcome to. I'm going to ask one more question before we do that. One thing that distinguishes this resolution from the other main piece of legislation that's oriented the same way, which is the NATO Support Act, which the House has actually adopted, I should say. The NATO Support Act similarly says the president shall not withdraw from the NATO treaty, but it puts it in a sense of Congress provision. And then it has a section similar to Section 2, which imposes a limitation on the use of appropriated funds for the purpose of, but otherwise doesn't have a binding statement of saying the president shall not do this in binding law. There's a reason to think, and part of the reason this looks this way is to get past rightness considerations, to get past political question doctrine in regards to Zivotofsky 1, this idea that if you have a really clear conflict between statute and the president's action, it's hard to argue that's political question doctrine. But there's also reason to think it fits into the Youngstown doctrine equation. We've seen Justice Kavanaugh say in his view of the Youngstown doctrine, his Minnesota Law Review article, that the last category, really, we're supposed to reserving that category. It's really important to have it, but it's for situations where we know there's a conflict, a clear, explicit conflict. How important does that weigh in your minds here? Does the NATO Support Act or other law that isn't as explicit as this fall short? Could there be cases where where Congress expresses consistent opposition to a particular action but doesn't prohibit explicitly? Example here is the INF Treaty. For 5 years at NDAAs, the INF Treaty, the Congress endorsed suspension, but I would argue implicitly says we don't support withdrawal. Does that put constitutional limits on the president's authority? Thoughts, anyone?
Well, it does seem like this statute goes a lot farther towards making sure this is justiciable, right? And so that seems helpful. Creating the direct conflict to me seems necessary, especially because Zivotofsky said, situations in which Congress has expressed objections, but then hasn't actually backed it up with lawmaking, that those are actually, evidence of congressional acquiescence. So the sort of direct conflict seems necessary, both, procedurally and substantively. On the appropriations, piece of it, I think the executive would say it's no more constitutional, right? Because Congress can't use its appropriations authority to basically leverage into a power that the president claims is exclusive.
But it is interesting that with Zivotofsky 1 refusing to apply the political question doctrine, there were reams of law review articles about, does this mean that the Supreme Court is normalizing foreign relations law? And then also with the marriage equality case, Windsor, they found legislative standing with the bipartisan legal advisory group, BLOG, right? Was that the Windsor case? I'm trying to remember. Yeah, it was Windsor. So, in both those cases, the court has been willing to kind of move past these avoidance doctrines to get to the merits when it wants to get to the merits. So it certainly could here.
And just to emphasize something that Don said, which relates to that, I do think in the real world, the big issue that I'm not sure we'd get over it'd be legislative standing, notwithstanding what Catherine just said about I think these doctrines are sometimes enforced strictly and sometimes they're not, based in part on the desirability, the court's desire to get to issues. And you could see all sorts of reasons they would not desire that in this case. The key case on this is Rains against Byrd from 1997. I've taught that case almost every year since it was decided, and one of these times I'm going to actually understand the case. But it says something about nullifying Congress's votes, and so I tell my students, the more you actually have a statute that actually has binding provisions in it that people actually recently voted on, the higher the case, and so this is probably better than a sense of the Congress. Although I think in either case, members of Congress could say, if they got it through the legislative process, that they took a position at odds with the president, and under their theory of the Constitution, the president is clearly violating their constitutional authority, and he's nullifying their votes by disregarding what they've done. But I think this statute is a bit better on that argument.
Yeah. Scott, just one point on the INF provisions you're talking about. I mean, if a court is faced with a choice where they sort of want to give the president authority here, and the options are finding that there's the implied will of Congress is opposed to it and the president has exclusive authority, or the concept of implied will, I think, is pretty slippery, and saying, oh, you're really in the zone of twilight, Youngstown category 2, and the president has the inherent authority. I think if there's any possibility of finding yourself in the latter category rather than the former, that's almost certainly what a court would do, is my guess, because of all the points that Kurt made earlier about the fact that it's a pretty big deal, I think, in this area to sort of rule the president could act at the lowest ebb.
Absolutely. Sir, to you.
Yes, I'm Carlos Vasquez from Georgetown. I have two questions, if I may. First, both Kurt and Don mentioned legislative standing as probably the biggest obstacle to this issue getting before the court. But I'm wondering what the panelists think about the plurality's position in Goldwater v. Carter. Do you think now that after Zivotofsky and Bond that that's not a viable position to take, that the issue of treaty termination is a political question that the court can't decide, or is it different because there's a statute? I know for Justice Powell in Goldwater that would have made a difference, but I'm not sure about the plurality. And secondly, Catherine mentioned briefly Brexit, and that leads me to ask about possible relevance of comparative analysis on this question. I know there's a controversy about whether you use comparative analysis in constitutional interpretation, but if you do look at comparative approaches, which way would that cut? My sort of preliminary thought is that comparative analysis, most countries do require legislative approval for treaty termination, but most of those countries are parliamentary systems where it's not that hard to get parliamentary approval. Our system is one in which legislation, it was designed to make legislation difficult. And so I'm wondering if there's that makes a major functional, makes our system functionally very different from those systems. And if we did require a statute in order to terminate a treaty, whether our hands would be tied much more than they would be for other countries.
So I'll take a stab at the first of Carlos's questions. Having garnered all of one vote in the first Zivotofsky case, I would think that the court would find it not to be a political question here, because you have a statute and you can make an up or down judgment on the constitutionality of that statute, applying separation of powers principles of the kind that were articulated in Zivotofsky 2 and other cases. The one reason maybe to come to a different conclusion would be that, at least in Zivotofsky, you had a statute that gave citizens a right to something, and that right was a right that they clearly had standing to vindicate. And it would be hard. It's hard in that situation to say there's a political question, and when Congress says yes, you have a particular right, and you can go to court and vindicate it. That wouldn't be the case really in the SJ4 kind of situation. But apart from that, I would think it doesn't seem like it's going to be a political question under Zivotofsky 1.
I basically agree with that. A couple of additional thoughts, though. I think Don's comment also reminds me that the legislative standing issues are not entirely separate from the political question concerns. They're kind of an overlapping, they come out of this Coleman case, which actually had both political question and standing all kind of mixed together from the 30s or something. If it was a political question, it probably is the second Baker against Carr factor, which is a lack of sufficient decisional materials. And a lot of our questions did push on how exactly do we craft a judicial ruling on this, even though there is a statute. My guess is that Don's probably right, because I almost read Zivotofsky as saying the constitutionality of a statute is just not outside of the judicial purview. It's really something the courts need to decide. So it'd be my guess, but on this lack of decisional materials, they've struggled with, say, gerrymandering, as we know, even recent decisions, because of the inability to articulate a standard. And I don't think they'll want to say, if they're in favor of Congress, across the board necessarily, for all the reasons we said, and maybe they're reluctant to do across the board for the president. So it may be tricky to articulate the line of decision. That would be the best basis for a political question.
Just on the Brexit question, reminds me of this one really wonderful interview that the British ambassador to the U.S. gave on NPR. They sometimes play for my con law students when we're talking about how you need two branches of government to get anything done in the U.S. And the British ambassador says in the interview, well, 200 years ago, you had a revolution to get rid of what you uncharitably called tyranny. But from what I can tell today, the U.S. government really can't get anything done because you need, Congress to act, or you need two branches. Well, of course, we could turn that right back around today across the pond, and it's impossible to, not look at the headlines recently and just see how the constitutional crisis that they're facing. Of course, the facts there are very different than the facts in this particular role play that we're doing. But nonetheless, it does make you think, gosh, if only they had a decider, right, to break the tie. And it's the whole, functionalist arguments that we discussed around swiftness and dispatch and having a single voice. But at the same time, the arguments here on the other side are, I think, equally compelling.
Sure.
MV3 has been set for tomorrow. Daniel Mandel, I'm a lawyer here in the district and a former student of Judge Bradley's. I was going to ask about the comparative law question as to whether there was some sort of, I don't know about norm, but just how do other systems do it, which obviously is outside the scope of the case raised before the court. But that would be interesting. But I wanted to ask about the consistency point. It was raised if you had some demagogue president, then they could undo all the treaties. But even without some sort of extremist executive, executives within the realm of left or right disagree on things. So take the Treaty of Rome, right? So one president could say, we're gonna subscribe to the Treaty of Rome. The next comes along and says, nope, I don't want to do this. So even something that's more mainstream, if you don't have the requirement to get Senate or some other branch involved, then you could very easily, every 4 years, have a quick change in what treaties are we members of, what treaties are we not members of. So wouldn't that type of thing counsel for inclusion of the legislative branch as well?
I have a question for Kurt actually on this. If the president withdrew, you would need advice and consent to get back in, which would sort of prevent the sort of ping pong effect that I think he's talking about. Is that correct?
Well, people are writing about this. There are some agreements that seem to allow a country to accede back into treaty regimes. Okay. And there is an argument floating out there in academic work that the original advice and consent is still sitting there. Okay. And it does not need to be renewed. That's going to be obviously a debatable proposition, but that would relate to this question of kind of a lurching foreign policy. Usually it's been in the context of signing up to things without Congress. Right. And we saw in the Obama administration with Iran and the Paris agreements, right. And then we just see a pretty quick turnaround. Right. But it could work the other way, and particularly if there's argument. UNESCO, for example, the United States has moved in and out of UNESCO unilaterally by the executive branch without going back to Congress, I think 2 or 3 times, right. Including most recently pulling out. So maybe that would address some of this. On the comparative point, it's interesting, in the majority of the constitutions that address, most constitutions don't talk about treaty withdrawal. A majority, that's interesting. We don't. I tell my students we only had like a half a dozen treaties, so we weren't heavily thinking about pulling out of those treaties at the time. So we were busy, and they were busy in Philadelphia in a hot summer. They didn't write it down. More and more constitutions are starting to address it, and they're starting to include the legislature more often. That is the trend. I have a book coming out that people have looked at this, and the trend is more legislative involvement, but it's a minority position. Obviously, everybody knows about recent decisions in, say, UK and South Africa, ordering the executive to have to participate with the parliament, the legislative branch. So there is a bit of a worldwide concern about executives maybe having too free of a hand and lurching their policies as a result. But it's still the case that it's kind of more common for the executive to control this diplomatic act. In part, international law, perhaps unhelpfully, just basically treats what the head of state does on this, and we talked about this, as a done deal. And I think the international community would just have a dilemma with what to do if they started having contrary orders from the domestic regime. And that may be a reason for a court to want to leave this more to politics as well.
There's also just the practice of the Caribbean countries that have pulled out of human rights treaties because of the death penalty and adverse rulings on the death penalty, and then rejoining these human rights treaties, but with a reservation not allowing, death penalty applicants basically to file. And I think also just with human rights generally, the thing that troubles me with these kinds of situations is that post-World War II, of course, governments signed up to these treaties to sort of tie their hands to the mast, right, in order to sort of prevent future leaders from, another genocide, from occurring. That doesn't mean we need to sort of take away one tool, treaties, as opposed to there are other tools, customary international law in the human rights context, but it does make me feel vigilant.
Next question, please.
My name is Enid Adler, and I have to, off the top, say that, well, first I'm following up on the last question, that I am a member of the NGO Coalition for the International Criminal Court. But this whole, as a United States citizen, this whole concept of the executive having so much power, and I understand the diplomatic part of it, and I'm wondering if there isn't some way that before the executive says, yes, we're pulling out of this treaty, because honestly, you have somebody now that's very happy to pull out of a lot of treaties, which can be detrimental to us in the long run. Is there some way of, before that act is taken, that there has to be some consultation in terms of what the ramifications are of pulling out in terms of our allies and others? And I remember being in The Hague where I had to say to Western European countries, I don't think we're going, this is right after the election, I don't think we'll pull out of NATO. You will be asked to pay more of your fair share. But I said, you will have to be stronger in making sure that you support the Baltic countries and others so that they know, because you're not going to count on us, so that they know that there's going to be somebody there for me. It was a very, very painful thing to say. And I was the only American in that particular small group discussion. So I'm trying to think of some kind of collaborative grouping, maybe that could be part of the discussion before the president does something like this. So whatever your opinions are on that. Thank you.
I'll just say a quick note. I do think that's a little bit more promising, even in terms of constitutionality, to try for Congress to get involved before the diplomatic machinery has already started something in action. And there is a bit of a model. If everybody remembers, it was controversial, but when Obama wanted to conclude what he called a non-binding arrangement with Iran with some other countries, the Congress passed the Iran Nuclear Review Act and got him to delay that while they were able to review it for a couple months and then decide whether they wanted to try to override it. And that wasn't obviously invalidated. It did delay even this non-binding executive action. So probably creative thinking in advance of these issues would be better than trying to do it after a president's already started. I think that's a good point.
Please.
I'm Alan Weiner from Stanford Law School, and I was just curious about the Section 2 issue, what the views are on the funding. I mean, it seems facially a little absurd that if the president is right, that he has the authority to withdraw unilaterally. But Congress could say, you can't actually do that because you can't spend the money for the postage to mail the notice in or to authorize the embassy officer to walk into the headquarters in Brussels. And yet, I think we've always viewed the spending authority to be an exclusive plenary congressional authority. So I'd be interested in the thoughts on whether Congress could effectively prevent this through the spending controls.
Well, it's definitely been the position of the executive branch for a long time in published opinions by the Office of Legal Counsel that Congress cannot use its appropriations authority to essentially invade the president's exclusive powers. So OLC has said that, for instance, Congress can't deny funds for particular acts of diplomacy, for receiving particular types of diplomats from particular places. I'm not sure that that's been tested in court, but that has been the longstanding position of the executive, and I think probably that if it were tested, the Supreme Court would be receptive to that kind of argument. It seems like Zivotofsky, by analogy, was saying, yes, Congress has passport authority. Clearly, they have plenary immigration and nationalization power, but they can't leverage that power in a way that that invades the president's exclusive recognition power. So I think that is probably how a dispute about that would come out.
Other comments? Ed, please.
Hi, Ed Swain, George Washington Law School. I came up here mainly to keep Alan company, but while I'm here, I have a question. And I apologize if you covered this at the very beginning. I was late to arrive. But I was wondering what you might think about the alternative, either as a way of testing the constitutionality of this proposal or as a possible consequence of a decision concerning the constitutionality of this, whether this same sentiment might be successfully expressed in a reservation, understanding, or declaration. And if so, what does that say about the constitutionality of a statutory alternative that might be passed by not only, by hypothesis, just say, 2/3 of the Senate and a majority of Congress, and also whether that might be a fallback position that might be a comfort, perhaps, to those who might wind up siding against their instincts with the president, that not only could Congress simulate the effect in certain circumstances by passing a domestic statute, but the Senate, if it were really up in arms about this kind of prerogative, could, as Kurt was saying just a moment ago, take charge earlier in the process and make that actually a part of the treaty consent itself. Thanks.
Thoughts? I know our council's we talked a little about this, so I know you guys have views.
I think that's, I think that, I guess 3 thoughts on this. One is, it seems intuitive that there's broad authority to condition advice and consent, so that why couldn't certain conditions on termination be part of that? I think that sort of runs into the question Don asked, though. Well, it's sort of just, if the president has exclusive authority over termination, it's not clear why you could use advice and consent to get at that when Congress can't use its other powers. So I think in some ways it doesn't work. There's also sort of a path dependency issue here, whereby a lot of the treaties Congress cares about right now were entered into decades ago, and what's Congress going to do at this point about NATO with its advice and consent and putting reservations and understanding? So, it could, going forward, I think since this issue has become more prominent, it might be something Congress considers, and I think they've been more active on the reservation understandings front, not just on this issue, but on a host of other issues about domestic effects. But I'm not sure, I'm not sure it's effective with a lot of the treaties people still care about that have been enacted in the past. And secondly, in some ways, I think it just reverts to the same question as to whether the president has exclusive authority here.
I'll add one point to that, which is I do think it's a stronger position to challenge the president than even the statute. And a couple of thoughts. One is historical practice. We have and Ed knows this, Ed and I spent about 5 years working on the recent restatement fourth, which has a whole section on reservations. The Senate's had 200 years of practice of regulating in this area, and it has passed often reservations the presidents haven't been overly keen on, but the regime has been that the president is not required to ratify a treaty, but if he or she does so, they're doing so with an understanding that these reservations are part of what they're agreeing to. So there is a certain consent element that is clearly not necessarily the case, although if they find it into law, you could make that argument. But at the time of the treaty here for NATO, if it had that, problem is obviously it's an older treaty that I think. Now, what I think might happen, if the Senate ever does want to try to insist on these reservations and try to use this authority, we will probably see some kind of a signing statement that says we're we're going to accept all of the reservations except for that one, and then we're probably back to square one like we are for some legislation. But I do think it's also the Senate's authority and the history, I think, that does help a bit.
Yeah, and just as a litigator, I guess I would say that there does feel to me that there's more of a textual foundation for the argument that Congress has authority when they do it as a reservation of the exercise of their textually based advice and consent power, which it's less true with respect to a statute like SJ4.
Absolutely. Well, we do have a question at the microphone, but that means I have questions. Just great. I organized this whole panel because I have questions. The question I'll have, which actually relates to this, is a common argument we've seen pulled out in regards to the reason why the president has exclusive withdrawal authority has been a parallel with the Appointments Clause, kind of parallel structure, text, essentially arguing that, well, the president could remove people he appoints. It's seen in Myers as kind of an inherent addendum to the appointments power. Why doesn't that apply to withdrawal as well? And there have been scholars, and I think even the government in a few arguments has suggested that's the case. There's a line in Goldwater that kind of implies that's the case, although I don't think it goes that far. What were your reactions to that? I noticed that wasn't an argument that was emphasized by.
I really wish it would have been, because I was really prepared for that question.
I remember.
Yeah, I mean, I guess I think it's a pretty good argument, a pretty good analogy. Sort of my litigation sense of it was that if I raised it affirmatively and relied too much on it, then we were going to go down a road into, well, you know, aren't there differences? Isn't the Appointments Clause an easier case because what we're talking about there is the president managing the executive branch. It's sort of an internal issue. It doesn't have the same lawmaking implication, and the president's, you know, power is strongest when he's taking care that the laws have to be faithfully executed, right? And so he needs to have that control over his subordinates. So at the same time, though, it is a helpful analogy because it does suggest that even where the Constitution expressly says the Senate has a role, it's not crazy to think that the president might have exclusive authority on the back end with removal of officers, and then so you can analogize to withdrawal from the treaties. So I thought it was helpful for that, but it did seem like it was going to get me into trouble if I raised it.
This is what happens when we invite an actual litigator to come to a moot court. Begin doing litigation strategy. Any other thoughts or reactions to that?
I would just note that if you haven't done it, you know, when the Goldwater litigation took place about Carter's pullout of the Taiwan Defense Treaty, the Supreme Court did not decide the question and had justiciability concerns, but the DC Circuit did decide. Supposedly this court decided. And it's an interesting opinion, and they basically try to go through the analogies, both the statutes, because in some ways treaties in fact have a status like statutes sometimes. And in that situation, we assume that the cancellation has to go through the same process as the making. And then they talk about the appointments where we obviously don't make that assumption. And they say, I think correctly, neither analogy works particularly well. And they say treaties seem sui generis. And then they have a lot of functional and other considerations. And so that's your litigation sense is probably a good one because I think either analogy runs into problems.
I mean, if it's it's sort of the opposite view of Ginger, which is I wasn't going to raise it affirmatively, but I was hoping I was asked questions because I actually think it's pretty good terrain for Congress because it does feel so different. Like the president firing people who are going to work with him just for the remainder of his tenure, as opposed to sort of pulling out treaties that exist in perpetuity. It seems like not just very disanalogous to me.
Fair. Yes, please.
Thank you. I'm Christina Voigt, professor at the University of Oslo. Between sending the letter of withdrawal and the point of time when withdrawal actually takes effect can be years. It can be several years. And I wonder, in the meantime, is there any is the power of Congress or the Senate in any way curtailed as to not enact laws, for example, in support of that treaty that was just withdrawn or was attempted to be withdrawn from? Is there anything that affects the power of Congress or Senate in that meantime?
Well, it's a very good, difficult question. Imagine a world in which we think that as a matter of domestic law, this came up, we don't actually have the treaty, but on the international stage, we do. And that would mean that, for example, arguments that there's authority to take care that a U.S. law is faithfully executed and gives power may not be technically available, I suppose. Or if Congress has special power to implement treaties that it doesn't otherwise have, which is true sort of under Missouri against Holland, that may no longer be true if domestically the treaty isn't part of our supreme law. it would be a difficult world in which we're bound internationally, but we lack all domestic effects of it. Yes.
Although I think it's kind of a parallel to the NATO treaty if the president were to choose not to implement it, right? Because there's a question about what authority Congress would actually do to force him to implement it and comply with it, even if it's on the books. I'll ask one last question, then we'll wrap up. We've talked here about Article 2 treaties, right? But that's just one type of international agreement. I think we have executive agreements. I don't think there's much argument, although actually I'd be curious to see if there are circumstances where we think Congress could restrict the removal of executive agreements. I guess actually there probably are. But I'm also curious about congressional executive agreements. And some of the preparations, I don't think we emphasize this much in these arguments. We talked about the fact that congressional executive agreements and the fact that they're now seen as an effective substitute, at least in many realms, for an Article 2 treaty, implies a congressional role. That's possible. What are your all thoughts about the relationship between what inferences can be drawn from the rise of congressional executive agreements for circumstances like this and vice versa? How a decision here might affect the treatment of congressional executive agreements?
I mean, I definitely thought it was a hard question for the president's side of things. I mean, it does seem like it pokes a hole a little bit in the idea that Congress has no natural role in foreign relations. So I think, what I would have said about it, I guess, is that you can't infer too much from what Congress can do under Article 1 in congressional executive agreements about what the respective powers are when the government decides to proceed under Article 2, but that's not a fully satisfactory answer because it doesn't answer the key question of, does Congress have a role here at all?
I think that's a bit what I was trying to get at with some of my questions about congressional executive agreement and executive agreement, to sort of tease out the differences on both those ends in contrast to treaties. But in some ways, I think what's really going on in the real world with Trump and the threat around NATO is as much about leverage and getting a better, quote, deal, as he likes to talk about internationally, even if he may not follow through on the threat, but to get the, NATO partners to pay more, for example. And, even where it's like the Paris Climate Agreement, where it's not binding, as Kurt was talking about with the Iran agreement, it's still, it's like a political tool to sort of make the point that he thinks it's a, quote, bad deal and that he doesn't buy the whole climate change argument to begin with. And it reminds me a bit of, George W. Bush with unsigning the ICC statute. Again, it was like, what was the legal effect of that? Well, it almost was beside the point. It was really making a political argument that he didn't really buy that the ICC was a valuable institution.
Any other thoughts? All right, well, we are almost at a close. If there are any last questions, we have time for maybe one more, but I think, yes, please. Somebody come up to the microphone.
My apologies, but will there be a difference if the treaty is self-executing and not self-executing, or in a treaty where Congress enacted an enabling law to implement a treaty? Will there be a difference in terms of the role of Congress vis-a-vis the withdrawal of the president?
I mean, go ahead.
So I think and I'd be interested in Ginger's view, I think if Congress passed a law implementing the treaty, whether or not, regardless of how we come down on this question, that law would still be enforced. And I don't think the president would, provided that law didn't infringe on the president's exclusive authorities, I don't think there'd be a question that law would still be enforced. On the non-self-executing versus self-executing, I mean, I think it's intuitively the case is harder for the president if it's a self-executing treaty, because then it's clear you're taking away something that has domestic legal effect, which seems, like, if you're thinking about all the various analogies, it brings it close to the analogy of just like taking away a statute in effect. But I'm not sure analytically it would affect whether or not Congress's action infringes on the president's exclusive authorities.
Yeah, I agree with all of
that. Can I do a follow-up on your statement on that? When you say if there's an enabling law,
yeah,
and that will not be affected, but when you go to the details, an enabling law implements the specifics of the treaty. So that's a little complicated, because if you have a law that implements something that is non-existent, what are you implementing?
Yeah, I guess it could turn on the details of exactly how the enabling law is written, but the enabling law would still be on the books and would still have force. Now, if the underlying thing it's pointing to isn't there anymore, it might say implement X and X doesn't exist. But I don't know. I haven't thought through exactly how that would act. I don't know if Kurt.
Well, I think it is complicated in the way you're suggesting, which is probably some implementing legislation will be interpreted to be conditional on the existence, a continued operation of the treaty. Why would we be giving one-sided benefits, for example, in a reciprocal arrangement? A court may conclude that that statute assumes that it will exist only as long as in some sense, it's conditioned on the treaty. Others are just changes to U.S. legislative provisions that don't seem absolutely tied to the treaty, and those certainly, I don't think, can be canceled by a president in any event. Having said it, if we're in the land of fantasy, if Congress can actually pass this, they can just pass all the implementing stuff at the same time and not make it conditional on the treaty, in which case, obviously, the president's bound by whatever, if they have the authority to regulate, which might be a question in the area we're talking about. But if they can regulate, they could just give all of those changes in the U.S. law and not make them conditional on the treaty in whatever area that would be. But I think I was thinking about this for NAFTA. I looked at the implementing legislation, which is like, hundreds of pages. A lot of it seems kind of contingent on there being a NAFTA, like arbitration disputes and things that are premised on us actually being a party. And so I think there's serious questions about what happens to that, the effect of the legislation if we withdrew.
Thank you.
Could I ask one question of my panelists?
Please.
What if Congress passed a statute that essentially was this act, but for all treaties?
I was going to ask you.
I'm glad you didn't, because obviously I don't have the answer to it. But I'd be interested in whether it changes the constitutional analysis at all.
I have no answers. So,
I mean, it seems like it might, right? Because
Yeah.
it seems like a pretty severe impingement on the president's general foreign relations authority, his ability to carry out diplomatic functions.
But do you have to do it treaty by treaty?
It feels like treaty by treaty is more constitutional.
Yeah. No, I'm saying
ASOL 2020, we'll cover this issue in another moot court argument. Well, perfect. Well, thank you all so much for joining. Thank you, my panelists, my judges, my counsel. I'll give them a round of applause. I'll get away from the microphone. And thank you all for attending. I have been instructed that they are converting this room immediately. As soon as we walk out, the floor is going to drop out like in It's a Wonderful Life, and will be a swimming pool. So we